Good afternoon. I'm Nick Friedman, and in this video I'm going to be offering you some advice on the basics of oral presentation. I want to offer that advice under three key themes. One, I want to talk about how you should structure your speech. Two, I want to talk about the appropriate way to deal with judges' questions. And finally, I'm going to talk through some comments on tone and style. Let's turn to structure. The general rule is that when you're structuring your speech, you need to begin by setting out what you're going to say. You then need to go on to say it. And finally, you say what you've already said. So step one is to draw a map for the judge. So for example, you might say something like, "My lord, I will be addressing question 1 in the moot problem. That is whether the threats of violence made by the police to the suspect constituted a breach of Article 3 of the European Convention on Human Rights. In addressing that question, I'm going to make two key submissions. First, I will argue that Article 3 encompasses not only physical torture, but also psychological torture and coercion. Secondly, I will show that the coercion in question in this case meets the minimum threshold of seriousness required for a violation of Article 3, as explained in the case law of the European Court of Human Rights." So that's an example of how you structure a legal issue in the introduction to your argument, just telling the judge where it is that you're going to be going, what he can expect to hear from your speech. In step 2, you then go on to each part of your speech, signposting as you go. Signposting just means that you're telling the judge what point in your overall structure you are now dealing with. What are you going to talk about, so that she knows where on your map you are. So for example, you might say, "My lord, I turn now to the first point on psychological coercion." And you'll then address that point for a little while, and you'll then say something like, "I turn now to my second point on the minimum threshold of seriousness." The more you signpost in general, the better. The third step is that after each point, you want to draw some kind of a conclusion to remind the judge of what you've just shown them. Remind them of the conclusions that you've proven in this particular stage of your argument. Finally, at the end of your speech, you want to conclude by showing what you've proven overall. So you'll say something like, "In sum, my lord, we've shown that Article 3 encompasses psychological coercion, and we've shown that the coercion in this case meets the minimum threshold of seriousness set out in the European Convention on Human Rights. For these reasons, we submit that the police have violated Article 3. That's the kind of broad conclusion that you'll draw, showing the judge that you've fulfilled the burden of proof that you've set for yourself. You may think this sounds repetitive, and indeed it is. That's precisely the point. It's a well-known and effective arguing technique used in debating and mooting, and indeed in real courts, precisely because it ensures that the judge is always absolutely certain when you are making your argument and why you are making the point that you're making. So that's the brief note on structure. Let's turn now to the question of dealing with judges' interventions. And here I want to address three aspects. I want to talk about the questions themselves, I want to talk about being appropriately deferential, and I want to talk about how to incorporate materials in your speech in responses to judges' questions. Firstly, the biggest mistake that people make in mooting is thinking that they have to conclude their speech as it's set out and finish it no matter what. The most important thing is to answer the judge's questions. It doesn't matter whether you get through your speech as you originally planned it or not. If you can do that, that's wonderful, but that's really a side issue. Imagine that you're in a real court. The judge probably already believes some parts of your argument that you're going to make. It's a waste of time to go over those points. The judge will have a couple of key, difficult questions that she needs the lawyers to help her to answer. Points that aren't clear on the case law, an ambiguous meaning in a statute, or conflicting lines of case authority. The best thing that you can do is to provide the judge with a structure, or a roadmap, or a recipe. To say to the judge, if you want to figure out the answer to this case, here are the steps that you need to follow. And the judges will then go on to quiz you on the finer details of the plan, the parts of the recipe that are difficult to follow, or the parts of the map that look dangerous to them or unclear. Bear in mind that judges are not always trying to catch you out. Sometimes they're throwing you lifelines when they can see you're struggling and are helping you to interpret a line of cases. So don't always view them with hostility. Moreover, you should bear in mind that sometimes judges deliberately pretend to be mean or difficult. Every panel of judges tends to have that one judge who's trying to trip you up, to be aggressive, to interrupt you as often as possible. They're doing that to test a particular set of mooting skills. So your goal is not to let that shake you, to remain calm and show the judge that you remain unflustered in the face of adversity. The final thing to say here is that you will often know much more about the topic at hand than the judges. You've been working on it and researching it for a very long time. The judges will be coming at the problem relatively fresh. So sometimes you may get a question that's completely off the point. In that instance, you want to deal with it politely. You want the judge to think that they've asked a good question. Again, don't be shaken by a seemingly irrelevant point. Just deal with it, contextualize it, and show why it's not relevant to the case at hand. Now let me say something about deference. It's essential that you are always respectful and polite to the judge. If the judge even looks like they're thinking about maybe asking you a question, stop talking and allow the judge to ask the question. You should never speak over a judge, and you should never interrupt a judge. One useful tip is that you can wait until the judge has finished asking their question. Take a short breath and then start to answer the judge's question. It ensures that you never interrupt them, and it also gives you a little bit of extra time to come up with the appropriate response. You should use the judge's title relatively often. Depending on the competition, you'll say something like "My Lord" or "My Lady," or if you're in an international court, you may say "Your Excellency." Don't go overboard, but the more you use that in your arguments, the more it seems like you're being appropriately deferential to the judge. In particular, it's helpful to start responses to questions with a respectful acknowledgement. So a judge will have asked you a question, and you can say, "Well, my lord, with respect, that case dealt with a slightly different point." Or you can say, "Well, my lord, it is true that that case dealt with an internal armed conflict between X and Y," and then go on to give the answer. So you're always just peppering your speech with deference. The final point I want to make is about the use of materials. You should prepare a file for the judge of all the materials that you're going to refer them to during the course of your speech. Cases, statutes, academic commentary, etc. Mark the pages with colored tabs so that you can direct the judges easily to the parts you want them to find, and highlight passages that you want them to read with you. You should also have copies of all the materials that you're relying on hand with you in a file at your podium. You can use tabs or post-its or other markers to show clearly what pages you've cited or you're going to quote. It means you'll always be able to access the material easily, and you and the judge will be on the same page. Let me now address some final issues on style. Ultimately, your speech needs to try strike a balance between two different extremes. You want to appear confident, but not arrogant. You want to appear respectful, but in control. You want to be calm, but not boring or impassionate. As a general rule, your clarity will be enhanced by speaking slowly and by speaking more loudly than ordinarily you do. Remember to maintain eye contact, not just with one judge, but with all the judges. And remember to use your body language appropriately. Don't lean on the podium, don't cross your arms, use appropriate gestures. You should also vary your tone as often as possible to make sure that you're not lulling the judges to sleep in a monotonous voice. Finally, bear in mind that some mooters speak quite emotively and passionately, others prefer a calmer, more relaxed style. It's totally up to you. You should do what comes naturally. Whatever you do, don't shout, don't become hysterical or worked up, and don't interrupt and irritate the judge. So that concludes my points on the basics of oral presentation. Once you feel like you've mastered those, you can go on to the next video, which deals with some advanced tips for impressing the judges. Thank you.